Hi, everybody. My name is Josh McDaniel. I'm the LA chapter president of the Federalist Society, and I've been told that I can plug one of our upcoming events. We're going to be having an event on February 14th, a lunchtime event. It's going to be at Munger, Tolles & Olson, and we're going to be having it's called Recollections of Justice Scalia. We're going to be having Ed Whalen, who's the author of Scalia Speaks, the collection of Justice Scalia's public speeches, and Judge Kuhl on the Los Angeles Superior Court, and Dan Collins and Henry Weissman will all be speaking about their recollections of Justice Scalia. It should be a great event. I know the Orange County chapter and the San Diego chapter also have similar events that week that are coming up, so something to look forward to. So, trigger warning. There might be hand waving during this panel. I'm here to introduce our moderator, Judge Ikuda. Judge Ikuda is a circuit judge on the United States Court of Appeals for the Ninth Circuit. She began serving on that court in 2006 after she was appointed by President George W. Bush. And before serving as a judge on the Ninth Circuit, she was a partner at O'Melveny Myers and was Deputy Secretary and General Counsel of the California Resource Agency. She clerked for Judge Alex Kaczynski on the Ninth Circuit and Justice Sandra Day O'Connor on the U.S. Supreme Court. She's a graduate of UC Berkeley, Columbia's Graduate School of Journalism, and UCLA School of Law. And last but not least, she's a great friend of the Federalist Society, and she embodies the ideals that our society believes in. So with that, I will turn the microphone over to Judge Ikuda. Thank you.
Technologically challenged here. Is this on? Is this on? Okay. Is this on?
Nope. Yes.
I'll borrow this. Well, first, thank you for that kind introduction. And I'm delighted to be back again with the Federalist Society to discuss First Amendment and campus speech. The past few years, I think, as you all know, have been very challenging for free speech advocates on campus. We have been hearing a whole new vocabulary: microaggressions, safe spaces, trigger words, and disinvitations. And I'm sure I've already committed a few microaggressions already. Our panelists today have been on the front line of the debates, so I'm going to give a very brief introduction. First, over here, Marieke Beck-Coon is the Director of Litigation at the Foundation for Individual Rights in Education, or FIRE. FIRE is a nonprofit organization that works to protect individual rights on college and university campuses, and Ms. Beck-Coon has been at the forefront of its activities. Before joining FIRE, she worked for the nonprofit Resources for Human Development, the Philadelphia firm of Schneider, Harrison, Siegel, and Lewis, and the American Civil Liberties Union. Next, Harmeet Dhillon, over here. She's a partner at Dhillon & Smith, which she co-founded. She currently represents the Berkeley College Republicans in a lawsuit challenging UC Berkeley's handling of controversial campus speakers. And I believe that the Department of Justice has just announced it's putting its weight behind Ms. Dhillon's client, right?
Yes, that's correct.
So Ms. Dhillon has won numerous awards and recognition for her pro bono legal work on behalf of domestic violence survivors, religious discrimination plaintiffs, and political refugees. Next, at the end there, Professor Michael McConnell is the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School and a Senior Fellow at the Hoover Institution. From 2002 to the summer of 2009, he served as a circuit judge on the U.S. Court of Appeals for the 10th Circuit. He then escaped. He also served as a law clerk to Justice Brennan. Professor McConnell has argued 15 cases to the Supreme Court, including some notable First Amendment cases. And in the past decade, his work has been frequently cited in Supreme Court opinions. And finally, at the end, the other end, Elizabeth Wydra is the president of the Constitutional Accountability Center, which is a constitutional think tank and law firm. From 2008 to 2016, she served as the center's chief counsel and represented clients in the Supreme Court and the federal courts of appeal. She also appears regularly as a commentator in major print and TV outlets. Before joining the center, she worked in private practice for both Quinn Emanuel in San Francisco and Pillsbury Winthrop in Washington. Please join me in welcoming our panelists. So let's start with the most high-profile free speech issue on campus, which is controversial outside speakers. There's both a legal and what Professor McConnell calls a moral pedagogical aspect to this issue, and we thought we'd start with the legal framework. So first, what are a public university's legal obligations under the First Amendment when students invite controversial speakers on campus? And I'll start with Ms. Dhillon.
Thank you, Judge Ikuda. It's a pleasure to be here. Let me start by way of background and say that I've been involved in this issue of controversial speakers on campus since I was a teenager at Dartmouth College. My predecessors at the Dartmouth Review, where I was the editor-in-chief, were Laura Ingram and Dinesh D'Souza, and we frequently brought some pretty controversial speakers to campus and had a running battle with our university. And being a private institution, some different rules apply to Dartmouth, but that's where I first came into contact with the ACLU that represented us there on some of these issues and have had a lifelong interest in this issue. 30 years later, it seems like the exact same issues that I was fighting at Dartmouth are awake and alive on campuses. And today, it is some of the most liberal institutions in the public sector sphere, University of Connecticut last week, and University of California, Berkeley, and many other California universities that have censored the speech of conservative students. So there's a legal framework, but let me set the stage a little bit about what happened at Berkeley with Judge Ikuda's blessing. University of California, Berkeley is known in California and throughout the country as the birth of the free speech movement on campus. In the 1960s, there was a movement by liberal students to open up the campus. There was a gentleman named Mario Savio who protested censorship by the University of political speech on the left. So as a result of that, Berkeley opened itself up, and it designated some areas of the campus to be open to the public. And one of those, any of you who went to Berkeley, Sproul Plaza is one. And there are a couple of other places on the campus where anybody can come and speak. And then there are other areas on the campus that have various limitations on them. What's unique about California is that the Education Code actually obligates the university, any of the UC properties that are governed by the regents, to open up their facilities, not just to students for use, but also to members of the public on a content-neutral basis. So what we're fighting at the Cal case is actually what level of scrutiny and what type of forum is at issue there. So back to the question that Judge Ikuda asked us, what are the public university's legal obligations under the First Amendment when students invite a controversial speaker to campus? And the answer is, it depends. It depends on the nature of the forum where the speech or the intended speech is going to occur. Now, as a threshold matter, the university's obligations depend on how open or how closed off they've designated that area to be. The more public the area, the more First Amendment protection applies to the intended speech. Under all circumstances, public universities cannot engage in viewpoint discrimination in any of their facilities, i.e., and I'm going to use the example that is actually live in our Berkeley case. On the topic of illegal immigration, for example, the university cannot ban conservative speech on illegal immigration while allowing the progressive or liberal perspective on that speech. In a venue that is more closed off, a limited public forum, which is defined by the case law to say that it is only open to certain groups or for speech on certain topics, then restrictions can be at a lower standard and they must be reasonable. This is a lower level of scrutiny, not hard to meet in most cases. The university has argued that most of its facilities are, in fact, limited public fora for purposes of the lawsuit that's ongoing. When a venue is open to the public for use by particular classes of persons, the university may not impose any content-based restrictions, i.e., it cannot ban the topic of illegal immigration, quite apart from the viewpoint on it, from being there, unless it satisfies strict scrutiny, narrow tailoring to fulfill a compelling government interest. One of the issues that we're facing is whether the university can allow a heckler's veto to interfere with the speech. A heckler's veto, in turn, is where the university is using the anticipated reaction to controversial speech to impose regulations on that speech that may regulate it out of existence. The university in a public space may engage in content-neutral restrictions, time, place, and manner, as long as the restrictions satisfy intermediate scrutiny, i.e. they are narrowly tailored to fulfill an important government interest and leave open channel communications, open other channels for communication. Now, in California, we have some additional regulations, and obviously other states may have their own. The Education Code in California, 66301 and 92204, they actually provide that the university, for any property that is open to, that is governed by the regents, which actually carves out some areas of the UC system, must not discriminate. And importantly, the regulations must be announced in advance. So if there are any content restrictions, they must be neutral and they must be announced in advance. They must have clear rules about who and when who may use the facilities and under what conditions. Where universities run afoul of these obligations are where they provide speech codes that have unfettered discretion for administrators, because that opens the door for discrimination. Another one of the issues that we can discuss here today is what is the obligation of the university to provide security in the event of an anticipated speaker who may cause protest and who may be controversial on the campus. This is one of the issues in the Berkeley lawsuit as well. The university is allowed to cancel a speech if there is an imminent threat of violence, not weeks in advance, but the day of the event. If there is a riot ongoing, as happened in one of the instances that's detailed in our lawsuit, they can cancel the speech. And another one of the issues that arises in the university is the coordination between the university itself and the local police. So again, at Berkeley, we have issues in the case as to whether police and university police were given stand-down orders on a content or a viewpoint discriminatory manner. Some guidelines that the courts have given us vis-a-vis how the university can comply with its speech obligations are that it needs to have clear rules with zero ambiguity or discretion afforded to university officials unless there is clear guidance on how the discretion is to be exercised. We believe, and this is an advocacy point, and some of the cases have said that universities have an obligation to or should put in place a framework for having factual findings for its exercise of its discretion so that these exercises can be appealed. These are also contexts that arise in governments dealing with permits for parades. There have been numerous instances in the cases where a city or a municipality reserves to itself unfettered discretion on what types of permits it's going to allow, using security as a basis for censoring unfavored speech. And where there are factual finding requirements and appeals in place, that type of a framework is more likely to survive constitutional scrutiny. And the issues in the Berkeley case, and the judge mentioned that the Department of Justice has weighed in. The framework was this. Last year, after the election, tensions were running high on the University of California, Berkeley campus. As you can imagine, and I'll talk about this later in the program, professors were telling students that maybe if they needed counseling, they'd be very upset about what happened at the election. Conservative students were being messaged by their professors to not talk about, not gloat after the election. I have examples of that. Students were being told not to refer to a potential wall as a wall, to not talk about that. One of my clients at UC Berkeley was told by a student that it was racist to refer to a border wall. He then attempted to reframe it as a physical structure at the border, and that was also not acceptable. So this is the framework in which, and I could go on for hours, but this is the framework in which the speech issues here occurred. Now, my clients, the University of California, Berkeley College Republicans, that's one of the clients, they're actually, believe it or not, one of the biggest college Republican campuses groups in the United States. So they have a long history of bringing speakers to campus and putting on good events. The local Republicans come to those events. So there's a lot of community interest, not just on the university campus, but generally it's been the practice that if the UC Berkeley Republicans have an event, people from the surrounding community come and see them. So after the election, they invited a series of speakers. Speaker number one, Milo Yiannopoulos. Not everybody's cup of tea. Let's just say he's a very flamboyant and inflammatory speaker. To their credit, the university did allow the students to book that forum for the speech, but they said, it's going to be controversial, we're going to impose a fee on you guys. Students had been used to booking rooms without any fee, but this time the university imposed a fee of $7,500. Now, this is a student group whose budget is typically a couple of $1,000s a semester. They don't have $7,500. They're eating ramen. These are not rich students at UC Berkeley. They're working their way through school, a lot of them. They found a conservative donor to pay the money. So all the conditions put by the university were met. But we had Antifa come to town, and there were black-clad pipe-wielding protesters who came to the campus and physically disrupted the event. In fact, the event did not occur. There was fires set on the intersection of the university and the school and the city. And as a result, because of safety issues, the university canceled the event, and that event did not occur. So the students were disappointed, but now they had a donor who could spend a little cash, and so they began to plan their next events. Young America's Foundation, which many of you may be familiar with, frequently partners with our conservative student groups to bring speakers to campus. Young America's Foundation agreed to underwrite the cost of bringing two other speakers to campus. They were David Horowitz and Ann Coulter. David Horowitz, many of you may be familiar with, conservative speaker on campuses and a conservative scholar. He was scheduled to speak at the campus. The students booked a room. They had a hard time booking a room. So the university administrators, mindful of the Milo Yiannopoulos riot, they said, okay, we'll let you book a room, but we're imposing a curfew on your event. The event must end by 3 o'clock. This curfew, by the way, has never been imposed on any liberal speaker on the campus. And the students said, well, that's kind of, okay, that's tough because students are in class. And they said, well, there's one more thing. The university said, you have to have the event a mile away from the center of campus. So it has to end by 3, mile away from the center of campus. So students who don't have cars have to travel to this remote part of the campus. And then they said, okay, well, we'll do that. We really want to have David Horowitz come. And then the university said, okay, there's another thing. You can't have outside people attend this event. So if you want to sell tickets, you're selling tickets to students who can't attend because they can't get there or they're in class. And so the students said, okay, well, that's going to be hard, but okay, we'll still like to do this event. And then they said, there's one more thing. You can't advertise the event until the day of the event. So you can't tell people where it is. You can't invite people off campus to help you subsidize the cost. And you're going to have it far away from the campus. The students said, okay, well, that's kind of hard, but we want to have this event. So then the university said, okay, there's one more thing. We're going to charge you nearly $6,000 as a security fee to have David Horowitz come speak on your event at a place where nobody can attend it. So the students are not dumb. They went to UC Berkeley, they did the math, and with the anticipated attendance of about 30 people at an event that's going to cost them $6,000, for $200 each, they can all go eat at Chez Panisse instead. So they decided to cancel the event as a result of these conditions imposed on the speech. Soon after that, the same month, Ann Coulter was invited to speak by the same group. And the interesting fact here is that the Berkeley College Republicans partnered with another group. It was a liberal group on campus, or a nonpartisan group, and they wanted to have a series on illegal immigration. So the two groups invited first Vincente Fox and Maria Echaveste, a Clinton administration official on immigration issues. And Echaveste presented the liberal position on illegal immigration, which is, it's great. We should have some more immigration, legal or illegal, in this country. Ann Coulter was supposed to be the counterpoint. So the university said, okay, you know, that's going to be controversial, so we're going to impose a curfew. And we're going to impose a fee. We're not really sure we can find a room, and we're not sure when we're going to let you have it. Are you sure you still want to proceed? And these students, they decided they wanted to proceed. Young America's Foundation was backing them up. So long story short, the university imposed a curfew. I think it was, again, 3 p.m. ending time. A requirement that they not allow outsiders to attend, unlike all other events pretty much on Berkeley campus. They could not advertise the event, and it had to be held at a securable location. So securable was one of the aspects of the university's policy. They wouldn't define what securable is. Surprisingly, Ann Coulter and these students agreed to all of these conditions. They were ready to go forward with the event. They said, how much is the fee? We never got to the fee part because the university said, guess what? We can't find a room for you to have this event at any time, at any day. And so then a national outcry ensued, and you know, you see on Fox News people talking about this case. The university got a little pressure. They came back and they said, we'll let you have the event sort of middle of the day during the week between the end of classes and the beginning of exams. So at UC Berkeley, a lot of students leave the campus. They go to study off campus, and that condition was not accepted by the students. And the university said she can come back and speak in the fall, but under all of the same conditions. Curfew, can't advertise, securable location, high fee. That's when I got involved, and Young America's Foundation got us involved. We filed this lawsuit. And we were challenging the university's imposition of what they call a high-profile speakers policy. The university admitted in discussions with the students that they had a special policy for high-profile speakers. And guess what? All of the high-profile speakers to whom this policy was applied were conservatives on the campus during the spring semester. So that's what we're fighting about in court. Ben Shapiro came to speak on the campus in the fall last year. That is now in our amended complaint. And as the judge mentioned, the Department of Justice filed a brief in support of our position in the First Amendment claim in the case 2 days ago. And the Department of Justice's position really looks at whether the university's vague policy, which after the lawsuit they morphed from the high-profile speakers policy to what they called a major events policy. The major events policy has all of the same constitutional deficiencies of the high-profile speakers policy. It allows virtual unfettered discretion on the part of university administrators to determine whether an event is going to require security, to impose a security fee, to require that the event take place in a so-called securable location, to limit the timing of the event, i.e. curfew, to limit the attendance at the event, i.e. number of people who can attend or types of people who can attend, etc. None of the criteria are identified in advance, and it is impossible for students to predict whether their speaker is going to trigger that policy. They have also imposed a limitation that if the event is going to have more than 200 people at it, they're automatically going to trigger the high-profile speakers policy. As a result of this policy, student groups, both conservative and liberal, have begun to censor their events, have begun to limit their attendance to 200, and have begun to avoid having big events on campus because of these conditions that are being imposed. So there's an ongoing constitutional violation at Cal, and we're hoping through this lawsuit to be able to move it forward. And I'm sure some of the other speakers are going to talk about some of the other legal issues that are implicated when these things happen on campus.
Well, before we talk about high-profile speakers and violence, as a personal note, my daughter was at UC Berkeley while these things were happening, and I was following it pretty carefully and calling her and saying, don't go and join the riot that's happening over by the student center. But before we talk about violence and high-profile speakers, let's find out whether private universities have any similar obligations. Most of the reports we've heard just assume that the legal structure applicable to public universities also applies to private universities, but that may not be the case. Professor?
This is a very difficult question. In California is unusual in the United States for having a law called the Clery Law, which does impose upon private universities the same free speech obligations that are imposed on public ones, whatever they may be. And so that's the law in California. It is not the law elsewhere. In general, the First Amendment has nothing particular to say about this because private universities are not the state. And there may even be a First Amendment argument that the Clery Act is unconstitutional. When a private university, which is not the state, itself has a position, it may have free speech rights to defend that by not having speakers come in against their will. I think that is not likely to be an argument made by private universities like my own Stanford, which at least purports not to be a partisan or a sectarian university, and thus is very unlikely to raise that kind of a defense, but it could very well be a quite serious and maybe meritorious defense on behalf of a university like Notre Dame or BYU that actually does have a particular position.
So let's turn to this question about high-profile speakers and violence. So where protests turn violent, and I think if you've been following the news at these campuses, you have seen incidents where the students and sometimes outside groups are organizing to do physical violence to speakers, to other students, to property. So what obligations do universities have to protect the safety of students and of the speakers, and how can they do that consistent with their First Amendment obligations? Marieke?
All schools and almost all universities and colleges are going to be obligated either through state law or through their own institutional policies to maintain order and safety on campus. So universities almost always going to start out with the mandate of being required legally and certainly morally to maintain their students and their community safety. So when you're talking about some of the instances of violence and certainly of disruption that we've seen when controversial speakers come to campus, and so universities and colleges are knowing that they may be seeing similar incidents on their campus. How do they handle it? So as Harmeet already mentioned, the first principle, I think, you have to start from the premise that listeners' reaction to speech is not a content-neutral reason to limit the speech itself. So, and we're talking about the heckler's veto. So when a school is facing an anticipated reaction, they have to, if they're a public institution or if they have similar state obligations as in California private institutions, if you're looking at a situation where you're doing an analysis based on an anticipated reaction to a controversial speaker, I think legally the solution kind of needs to be aimed at allowing the speech to take place in the first instance and protecting the right to speak. Because if a listener's reaction is not a content-neutral basis for limitation, then you're going to be subject to strict scrutiny, as Harmeet mentioned. So if you're subject to strict scrutiny, I think you're, as the college, you're saying, okay, we need to start from the premise that we need to figure out how to make the speech happen. Canceling or shutting down needs to be a last resort. And you saw that, you've seen that the courts come to that conclusion in the context of, for instance, Richard Spencer coming to campus. Last court in Middle District of Alabama last April ruled when Auburn tried to prevent 4 days before Richard Spencer was anticipated was contracted to appear on campus. They canceled his event in citing safety and disruption as the reason for the cancellation. And the court in that case said no, you can't. Again, this is the heckler's veto in this case is. The court can't, or the school can't use the excuse of the heckler's veto in the circumstances presented in that case. And I'll talk about a little bit how the circumstances in that case were different or could be different than in other cases. But the court there said you got to let go. They granted a TRO and said, Auburn, you got to let Richard Spencer speak. He's rented your space in the same way that any other speaker would rent your space. And the court, in its injunction in that case, specifically said that security personnel couldn't cut off the free speech rights of Mr. Spencer to speak, except as a last resort, and cited to a case out of the Sixth Circuit in 2015 called Bible Believers, where the Sixth Circuit came to the same conclusion, applying strict scrutiny to a heckler's veto situation. So universities ahead of time looking at how they're going to create policy or create approaches that deal with potential disruption, or that deal with large events, that deal with speakers in general. I think colleges and universities should do the homework, particularly based off of what we've seen at campuses across the country. They need to do the homework ahead of time to put in place content neutral policies, and Harmeet already talked about a number of aspects of what that looks like. But that when forming a policy, a college, what should their aims be? Viewpoint and content neutrality. In practice, is that hard to achieve when you're talking about when you use the language of standards of disruption? Potentially, because it's always going to be colored by who's coming to speak. But in service of forming a policy, or of coming up with a policy that's viewpoint and content neutral, as Harmeet said, standards that are sufficiently definite and objective are crucial. And written decisions and appeals processes are crucial. So when law enforcement and administrators are looking at an application for a certain to reserve a certain space, or to have a certain event, they need to show their math, and so that math can be evaluated by an appellate process, and you need to have an appeals process. So decisions and reasoning, in showing that math, need to be rooted in demonstrable evidence that's connected to the need for specific limitations or security requirements. Basically, it can't be. The Supreme Court has made clear that kind of that speculation or kind of an unproven fear of potential disruption is not a basis for limiting or limiting or censoring speech. So, particularly in situations where you have a speaker like Richard Spencer who is on a college circuit, like he wants to go to colleges. The extent to which the colleges are making their security assessments, they need to be making security assessments that are specific to what the anticipated what's anticipated in their community, and not necessarily like this happened over there, although, you know, I think the colleges are facing, in some cases, facing a difficult time where a history of what happened is also coloring their understanding of what will happen in their own community. And I think that kind of, it's a fact-based question that courts will balance as more lawsuits are filed in this area, particularly by Richard Spencer, who likes to file a lot of lawsuits. Security costs, how can security costs be imposed in a content neutral manner using objective criteria like size of the event, is security usually handled at a certain venue? Is the audience anticipated to be made up of members of the public or solely members of the college community? Insurance requirements that are applied to all speakers or applied to everyone equally for a particular venue. These are, again, colleges need to just be looking at this and saying, are we handling and treating groups equally? Are we look at that content neutral and viewpoint neutral, those factors at the outset, but then when applying those to given situations or something that's coming to campus soon, again, you go back to if you're basing your decisions on the anticipated reaction or the anticipated the security concerns, then you do kind of have to go back to the premise of we need to get to yes for protecting the speech or the ability of the speech to happen, and using censorship as a last resort. I think that you'll see this. The interest, courts treat the interest differently in this area of litigation as it develops, as between outside speakers that have no affiliation to the college and are not being invited by college community members, and situations like the Berkeley College Republicans, where you have a student group that's inviting a speaker that they want to hear. I think that courts are going to treat those situations differently in terms of what the college's interest is, and how the court will weigh their interests. Because if you're talking about a court analyzing a heckler's veto, they're going to apply strict scrutiny. If you're talking about if you're talking about a limited public forum, or a public forum, you're going to get intermediate scrutiny. But so depending on the forum and depending on what level of weight the court is, or what requirement the court's looking at in terms of how important the university's interest needs to be to impose a restriction on speech. I do think that both the Supreme Court and appellate courts have kind of long recognized kind of a difference in even in public college settings between the interests of students and community and the interests of outsiders, so to speak, to exercise First Amendment rights on campuses because of the educational purpose of the university. And I think the Supreme Court has long recognized that the space is meant for educational purpose, and the university can act accordingly. So I think that's going to cause the courts to play out differently in terms of how they're looking at, for instance, a Richard Spencer, where he generally invites himself to college, and situations like the Berkeley College Republicans, where it's a student group who's trying to exercise rights and benefits to being in a university that are enjoyed by other student groups. I think that the way that that's going to play out is in how courts are in the level of burden that the court is going to be inclined to demand that the college bear. So the way that this is, we've seen incredibly high security costs being borne by universities in order to provide security for controversial speakers in recent months. I believe when Ben Shapiro came to Berkeley, it was hundreds of thousands, $500,000, $600,000.
They claimed it was $600,000.
That the university, that Berkeley claimed that it spent on security. When Richard Spencer spoke at University of Florida, the reports were, $500,000 spent on security. A national emergency was declared by the governor. 800 extra security personnel and law enforcement were brought in from outside communities. And effectively, the University of Florida was essentially shut down for the day in practical terms. Now, this is all of those facts were recently brought up by Ohio State University in response to Richard Spencer suing Ohio State for refusing to allow him to speak on campus, for refusing him the ability to rent space there. And that's ongoing, but Ohio State just filed an answer which included a good deal of rebuttal reasoning and legal argument about why Richard Spencer's First Amendment claims by Cameron Padgett, who's essentially the guy who books Richard Spencer to campuses and tends to be the plaintiff in his cases. Why Cameron Padgett why his First Amendment interests were not going to prevail over the universities in their case. Their argument was that in light of violence in Charlottesville, where Richard Spencer was present, in light of the incredible costs of borne by the University of Florida to secure the campus when he came there, they argue that in light of that history and the anticipated costs that they would have to bear in order to get him to allow him to be able to speak safely on Ohio State's campus, that they argued that the idea that his rights trumps the rights of the 100,000 students and employees at Ohio State to the enjoyment of their campus, essentially without class closures and cancellation and unreasonable security costs borne by the university, taken out of the students' pocket, so to speak, that they argued that the idea that his rights trumped that kind of substantial burden on the college and its community. It ain't gonna fly. We'll see how that turns out. I mean, you got that versus the Middle District of Alabama's decision in the Auburn case last April. We'll see how that goes, but I could imagine that there will become a point where a court's going to say, based on demonstrable evidence about what it's going to cost you, maybe we will allow you to refuse an outside speaker. But is that a court going to treat that differently from from a student group's right to hear speakers on its own campus, analogously to other students? I think those will be treated differently. But food for thought.
So,
I make just a quick legal point about this, that I don't disagree with any of that, and I'm all in favor of holding universities to a content and viewpoint neutral standard with respect to their policies, but none of this is going to help very much, and the reason is this. Imagine that you have a violence probability meter which is completely objective and knows everything. So we actually know what speakers are likely to cause the campus to erupt in violence. And so it's completely viewpoint neutral, and the university just turns on the violence probability meter and tells you what the answer is. What this means is that speakers who are unpopular among violent groups are going to not be able to come to campus. And this is not, in fact, a viewpoint neutral thing. We are not living in a world in which you have equally large and violent organizations on the various sides of the political spectrum. It's going to be targeted against particular people. As long as we continue to talk only about the kinds of reforms that Marieke was just talking about, and they're all reforms about when should the university be able to shut down the speaker. That's what it's, everything she talked about is that question. As long as that's all we're talking about, it's a losing battle. What has to be talked about in addition to that are serious sanctions against students and outside groups who are violently disrupting speakers. Because currently, if you put yourself in the shoes of a violent student group that wants to get rid of a speaker, you come out, you know, in your balaclavas and carry your clubs and you do all this stuff, and maybe you'll shut down the speaker, in which case you win. Maybe you won't, like, you know, or maybe you'll get slapped down by the court like 3 years later after we go through all this balancing and tiers of scrutiny and whatnot. And remember, all this is going to be in the Ninth Circuit, so don't hold your breath for very good applications of fuzzy standards. No, it has to go. There has to be a risk each way. So Claremont College recently actually imposed sanctions upon the students who disrupted speech. They were kind of mild, which I think is fine. You don't start out by, you know, with all great guns, but some sanctions I think are going to be enough to, if they're predictable and quick, it's going to be enough to shut down a lot of this kind of commotion on campuses. And then I would also, to the extent that you can identify outside groups, go after them, get all of their assets, RICO challenges. This is the strategy to protect free speech.
I just want to add one data point. I agree with everything Marieke said in terms of what the legal framework is, but one dirty secret here is that these universities are creating their own hecklers by their own messaging, their own hysteria. So in the case of University of California, Berkeley, professors and university administrators, people with the title dean in front of their names, dean of students, are messaging students and saying in advance of speakers, I mean, how many people here have heard Ben Shapiro speak? Is it shocking? It's not the type of speech that, it's not Richard Spencer. It's not the type of speech that, you know, you need to have mental health counseling about when you hear it. It's actually thoughtful. You may disagree, you may not disagree, but it's not that offensive, objectively. So when University of Connecticut, University of California, Berkeley administrators tell students they should be upset, they might need counseling, they might need mental health treatment and resources if they hear this speech, then you have students coming out, like in Ben Shapiro's speech, speech is violence, we will not be silenced. You know, these are the chants of hundreds of students. So the $600,000 spent by Berkeley, 2 years earlier Ben Shapiro came to speak, no protests, no drama. This is when Obama was the president, the political system was totally different. So the same speaker, without all the accoutrement of impending riot by the administration, is no controversy. 2 years later, it is $600,000 worth of controversy. So the responsibility needs to be placed on administrators as well to keep the peace.
Well, let's talk about what the universities are hearing, which is more of a moral pedagogical question than a legal question. And universities are hearing that they should be protecting students who are victims of structural racism and may be traumatized by speech, Ben Shapiro or others, that makes them feel vulnerable and targeted. What are universities' responsibilities in that context?
Thank you so much, Judge Ikuda, and thank you to all of you for having me today. I am the president of a progressive organization, and I should say that I always welcome coming to Federalist Society events because I greatly value the importance of civil discourse, particularly amongst those of us who might have disagreements with each other. And I think that leads into exactly what we're talking about today. And one thing that I think is important to remember, we've been talking a lot about from the perspective of the people who are feeling that the speech they want on campus is being excluded. Professor McConnell just brought us into the shoes of the Antifa protesters. But I'd like to think more generally, pulling it back a little, and think about these young people who are at this crucial stage of their lives, who are coming onto a college campus with their own backgrounds and identities and feelings about the world and experiences that in many cases have had them felt vulnerable and attacked because of who they are, where they come from. Not everybody. People have different experiences when they come to college campuses, but there are a lot of people who have good faith concerns about someone coming to campus and telling them that their humanity is less than others, because they're there to learn. They're there to have an equal opportunity to get an education. And so when that experience that they have been a part of, been subjected to in their outside life, is then seen as legitimized by the school, then that affects them. Now, I am a pro-Constitution lawyer. I have always, actually I went to Claremont McKenna College. I am deeply ensconced in constitutional text and history, so you're not going to hear me up here advocating that we don't follow the First Amendment. I think we should. I think we should follow the letter of the law, and it's important for schools to do that. I think it's even important for schools that are not necessarily required as private universities to follow the First Amendment, but for them to follow the principles and values, because it is an important foundational part of our democratic society. But I would also ask everyone here in this debate on campus free speech to recognize that for many students, not all, we all have a diversity of experience, but for many students who are women, gay or lesbian, a person of color, from a minority religion, or some mix of all of the above, the reaction to the offensive speech is going to be different than it might be for some of us, some of you all. And by that I mean, we talk about the importance of the marketplace of ideas, especially in college campuses, because we want people to encounter new ideas, to grapple with these ideas. And people will say, well, if these liberal snowflakes don't allow these offensive speakers on campus, how will they ever learn to fight back to that kind of, and I mean that verbally, I absolutely do not condone violence of any sort, but how will they be able to push back against that argument? Well, let me tell you, if you are a woman of color, it is not going to be Richard Spencer on your college campus the first time that you're going to hear the argument that you are less than someone else because of the color of your skin or your gender. That's not going to be the first time you've heard that argument. People from marginalized groups have been hearing this their entire life. They don't need Richard Spencer or Ann Coulter to come to campus to expose them to this idea. They've been exposed to it their entire lives. And so while there are some conservatives on campus who rightfully feel marginalized, and I don't think that's appropriate, but might feel marginalized during their years on the liberal campus, when you leave the university, you go back to a different life than someone who goes back to being afraid of being stopped or even shot on the street by the police because of the color of their skin, or being sexually harassed in the workplace. It's just something that different people bring to this marketplace of ideas. And so I would just plead for respect and compassion and empathy. So that's the human point. But now I'd like to make a constitutional point about what the universities should be thinking of in these instances. As I said before, I am a proponent of the First Amendment, and I believe strongly in both the letter of the law and the spirit behind it. But that is just one of our constitutional values that comes to bear in this debate. Through our country's arc of constitutional progress, we have amended the Constitution to put into the text the promise of the Declaration, that all are created equal. We did that in the 14th Amendment. We did that in the citizenship amendments that said that no matter the color of your skin, whether you're a man or a woman, whether you're rich or poor, you are equal in our society. And so that's also an important constitutional value to bring here. I'm not saying it overrides any of these First Amendment points and it says that, you can ban all these speakers. That's not what I'm saying. But when we talk about the values that are involved in this debate, please also think of those values of equality and inclusion that are just as much of our constitutional legacy as free speech. So finally, how do you deal with both of these? It's hard. I think that it is difficult to find a way to ensure that people feel respected, feel part of the community, while at the same time respecting the right of student groups to invite these controversial speakers to campus. But I think that one way that I might suggest universities think about it is to think about how they can make clear that they're embracing all of these values. To make clear, perhaps through a statement saying or even a training course as part of orientation, to say that the First Amendment is important, it will be respected, but so also are the values of equality and inclusion that are not only our constitutional values, but presumably the values in which we can, as a community of scholars and learners, best engage our minds and engage in the debate that is so crucial to young people at this stage in their lives. So that's what I would ask that we keep in mind. I think it's important that we come at this with sensitivity and respect, which I know might be, you might start saying, trigger warnings, blah, blah, blah. But I actually don't think that's very funny. I mean, there are people who do experience what people call microaggressions because of their experience. There's science that shows that you can even have medical consequences from the daily racism you experience. So I just would ask that we engage, especially those of us in this room, in this debate without laughing at our friends, without without overlooking that other people might have had different experiences and hear things differently than we do.
So may I comment on that?
Marieke.
I'd just like to make a quick follow-up point to that because I very much agree with you that the university, and I think the university has multiple types of obligations to its students, and that what universities really need to be able to do in this, particularly in the climate that we're facing now, and the increasing polarization that we're facing now, both outside and outside of campus and on campus, is to make very clear in its actions and its communications to its students that the values of open debate and free speech and the value of diversity and inclusion and creating a campus that is a campus for all are not exclusive, and they're not mutually exclusive, and they can both be achieved. And universities need to be unbelievably transparent and engage in that affirmative messaging and talk about it, and talk about where tensions lay, and be honest about that when they do, and say, here's how we're going to talk about it, and here's what we're not going to turn away from that, we're going to turn towards that, and we're going to create new fora and new spaces to continue to engage in that conversation. And I think that it's incumbent on university administrations and university communities in general to make clear that there is a huge difference between policing language and addressing language. And that there is value, high value in separating those two, because it is not the place of a university to define the permissible scope of conversation on any campus. And I think almost every student body is going to agree with that, particularly when you point out, like when you talk to students about like the consequences of what that looks like. If you're handing over if you're handing over decisions to an administration, to an authority, and in the context of a public university, a government authority, to say what you can and can't say, I think it becomes pretty clear pretty quickly how that hurts everyone. And as history has borne out many, 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 many times. But a university can also say, and can also facilitate, instead of talking about whether something can be said, let's make the focus on the implications of what is said. So when we talk about how people, how you even define a microaggression, but how a microaggression may be experienced by different people, by different people in an increasingly diverse college and university and college community nationwide. Let's have that conversation. Let's not talk about whether a microaggression can be said in the first place or should be policed, which is unfortunately, I think, kind of where we are right now in the conversations that we're having on campus, or the conversation is about what can be said. That is absolutely, that detracts from the substantive conversation that's underneath. And I think that universities need to do way, way, way more to parse that out.
I just wanted to say I agree in the abstract with what Elizabeth was saying. It is important. Universities have different tasks, and the values of equality are right up there, and they shouldn't all be pushing free speech all of the time. But I wonder, Elizabeth, how much time you spend on a modern American campus. I'd kind of like to invite you to come to Stanford and see. We have literally dozens of assistant deans in charge of inclusiveness and diversity. There is not a single member of the Stanford University administration whose job it is to protect freedom of speech. Under the rules, if you look at them at Stanford, if a student is offended by a statement made by a fellow student, there is a place where they can go lodge their complaint, and then there's going to be a university investigation of the speech. If your speech has been suppressed, if you're a student and your speech has been suppressed at Stanford, there is not a place you can call where you can lodge an objection and get some help. So just a few days ago, I was contacted, because I teach the free speech course at the law school. I was contacted by an undergraduate. In his dorm, some people had put up a bunch of flyers asking folks to report any activities by ICE, by immigration authorities, giving a number where you can call and saying, keep our campus safe, from the ICE. So this undergraduate, being 19 or whatever, he's a little, maybe a little immature, decided to put up a flyer satirizing this. And so he replicated the graphics and color, and he said, be sure to report any law enforcement activity on campus. Keep our campus safe. And what happened to him? What happened to him? First of all, so he put it up on the bulletin board in his dorm. It was taken down by the dorm authorities, first of all. He was then called in for a meeting. 12 people attended the meeting, plus himself. Every one of the RAs and the residential assistants and so forth were shouting at him. There were 3 students there who were crying and claiming that they had suffered. They felt that his flyer made them feel unsafe. And he contacted me and says, what do I do? Right? And I said, well, first of all, it couldn't be clearer under Stanford's ostensible free speech policies that he had every right to do this pamphlet. Right?
Were they going to sanction him for it?
They just took it down. What they were going to do is make him go to a series of meetings He was being investigated for
is a sanction.
thought crime.
Yeah.
This is thought
No,
crime.
I just want to be clear. Like, when you say thought crime, what exactly was going to happen to
He
him?
was going to be hauled before a series of administrators and asked, why would you do such a thing?
Isn't that just the exchange of ideas?
No.
Come on.
This is authorities with
look.
power over him telling him that he committed bad think. Right? Read 1980. 1984 should not be treated as a how-to manual by modern universities. Now, I am all in favor of balance. But when freshmen come to Stanford, they are treated to a whole series of wonderful lectures about inclusion and diversity. They are not treated to not a single official speaker during student orientation week talks about the values of free speech or what it means. You talk about training. You have these RAs and people running the dorms who do not know what free speech means and tell him that he doesn't have a right to put up this flyer. We do need balanced training, and we need a balanced message, and there is no balance on American universities today. And what I would really like is if universities would do an environment survey, similar to what they did in the sexual assault context, an environment survey in which they ask people, do you feel free to express your opinions at Stanford or Ohio State or whatever, and find out what the state of freedom of speech is. Because I hear all over the country, I hear conservative students saying that they will not speak up in class. And the reason isn't necessarily that they're going to be punished. The reason is because there is a mob mentality in the universities in which if they do express their opinions honestly, they are going to become pariahs.
Can I talk one more comment? So adding to what Professor McConnell just said, I can say that as one of the few conservative lawyers who takes these types of cases in California, I have had calls from a dozen university campuses in the past year with similar stories to what he just talked about, and students who step out of line, particularly on an immigration issue in a situation where we have a sanctuary state now, are punished for their views. They self-censor, which is part of what we're going to talk about here as well. And the dirty secret, Elizabeth, of equal protection and due process on colleges' campuses today is that it is the conservative students who are being denied due process and equal protection. And they're the ones who are in the minority. And by the way, they have been. Like I said in my comments, back at Dartmouth 30 years ago, the ACLU was still taking cases of speech for conservatives. The ACLU lawyers represented me and my friends when we were in trouble with the university for similar thought crimes. Today, they don't do that. So there's actually fewer champions for conservatives on campus. And they're the ones who professors single out. They're the ones who get hauled in front of their deans. And these are ambitious kids. If you're at UC Berkeley, their careers are being threatened by other students. We will destroy your career. I have examples of this: flyers, emails, text messages. And that's unacceptable. So it goes back to what the universities their obligation is. They have an obligation to create an equal and level playing field and not favor one viewpoint over the other. And unfortunately, I don't hear, and I know Marieke might have some examples, but for the most part, it is one side whose views are being censored. This is not an equal opportunity problem across our campuses.
So I just want to say that, I absolutely agree with you that students with conservative views on college campuses deserve equal protection and due process. That's kind of the point of those constitutional principles and values. But they aren't the only ones. So I think when you say, on today's campus, these are the victims, well, we all deserve equal protection and due process. So I think getting into this either-or mindset, where we get into the either you're in favor of shutting down speakers or you're on the side of Richard Spencer, we should be able to come to something that is more reasonable. We can do that. And I totally hear Professor McConnell on his point about that particular student. I think for many students coming into college where you have this conflict of experiences and ideas and positions is something that's important. And it's something that should be navigated. And so I think absolutely something in the beginning of orientation when you're talking about diversity and inclusion, talking about the First Amendment, and I would put those two together, how you talk about free speech and how you talk about diversity, having that in the same conversation is incredibly important and important for that balance. So it should happen. But I think the idea that somehow the people who are, those students who saw those ICE flyers, I will accept Professor McConnell's invitation to come to Stanford. I might suggest that he spend more time off campus. I've worked a lot with the Dreamers, and they're some of the most inspiring people I know, and they are terribly afraid right now of being ripped apart from their families. And however you feel about that politically, that is a real feeling. And so I totally get your point that that student shouldn't be forced to take down his expression of his political view. But to make it seem like it's 1984 and some thought police, when a student generally might be scared to death that her mother or herself or her sister is going to be taken in the middle of the night, people I know have those fears. I don't think that's a helpful way of getting to a solution in this conversation.
So we're running out of time, but let's talk briefly about this question of the threat to free speech from students suppressing and censoring other students, and I guess also some administrative activity, but leading to self-censorship. And we do have these competing concerns. We have the universities wanting to encourage and protect free speech among students, but also a concern about teaching civility and protecting students from hate speech. So how do we balance these two competing goals? Let me start with Marieke here. And if you could just, we're sort of running out of time, so just briefly state your ideas and we'll go around the panel.
I think we've talked about this a little bit, but I think that balancing the competing interests is a matter of transparency and affirmatively engaging in the discussion and the honest conversation about where if anywhere there is tension between values, particularly when you're talking about what what students perceive as hate speech or hurtful speech or whatnot. So saying, so again, maybe going back, like going to the orientation or other trainings, having other trainings, or creating other fora during discussion fora over the course of your education in somewhere that addresses the First Amendment and free speech values alongside, as you were saying, alongside other questions, and as I said before. Making clear that there is a difference and a significant value difference between policing speech and talking about speech and addressing the language and the discourse that we use with each other. I mean, it's certainly it's very, very helpful, I think, if universities have clear definitions of things like actionable harassment, threats, and other kinds of unprotected speech, so that you don't end up in a situation like the Stanford student, where you have a policy or you have rules at a university that allow for the punishment or a disciplinary investigation of something that's clearly satire and clearly protected speech. So in order to prevent that at the outset, have clear definitions, have clear constitutionally compliant policies, or at private institutions, the equivalent of constitutionally compliant policies. That goes a long way towards setting the the boundaries of what the university understands its sticks and carrots to be. So if a university has says here are baseline policies, so we as administrators understand what we are to react to and not to react to, or how, like what tools we have, be it the disciplinary process, because they, it's an administrator, so they're thinking about it in terms of tools. The administrative process, disciplinary process versus a campus conversation or campus forum. Like, how are they thinking about attacking the problem? I think that having a clear administrative direction on that and clear policies is going to go a long way.
Professor McConnell?
I just want to say this is a genuinely hard problem. This isn't something that people have tried to make hard. This really is hard. And the reason it's hard is that students, like all citizens, have the right to express contempt for what other people say. So a student who believes that somebody who favors, say, the wall or doesn't want to do the dreamer thing, and they think that that person is a racist, have a right to say that that person is a racist. It may be offensive, it may be hurtful, but there's a right to criticize other people, and oftentimes that's going to be very hurtful, and it's especially tough when you have overwhelming one-sidedness in the population, so that it tends to be directed at a minority rather than evenly distributed. But the university cannot shut up the students who are making other students feel bad. That would be a violation of free speech too. This has to be a pedagogical matter, and it's a subtle one because it's extremely contextual. But it would be good for universities at least to make a stab at modeling civil speech. And it would be helpful, for example, if universities themselves would invite speakers of different sorts. And I think it's also helpful for faculty who are trusted by students to try to help to educate them. So I often talk to conservative students who, about things they sometimes come to me and ask, and my advice to them is always, be more civil than the other side. Think about how your speech is going to be heard by somebody else. Is it going to be hurtful? Do not be hurtful, right? Be kind, be civil, be better than they are, and also have a thick skin, right? Don't be a crybaby, just be about everything. But I can say this to a conservative student because they know I'm not trying to shut them up. They understand that I am their friend and I'm giving them advice. I like to think that there are left-of-center professors who are doing the same thing with left-wing groups. I don't actually see it. But it would be, I like to think that maybe, and part of the problem is that universities have so few people of my ilk teaching, or zero in administration as far as I can tell. And so they're kind of paralyzed. I utterly grieved. I was away at NYU in the fall. I wasn't at Stanford. I was visiting at NYU. And I grieved. I was just stunned and shocked and horrified when I heard that the college Republicans at Stanford had invited Spencer to come and speak. I so wished I could be there and just say, and have a quiet meeting with those students and say, please, don't you see what you're doing when you associate your group with somebody like that? The harm is not being done to the other side. No, like Spencer has no moral authority. He's not going to persuade. And the harm is being done to the college Republicans when they invite him, and it's harm to the entire movement by besmirching the movement with this kind of invitation. But I might be able to communicate that to the group. If it's some left-wing administrator in power calling them into the office, they're going to get their backs up. They're going to say, you're censoring me. They're going to say, the very reason I assume that they invited Spencer is precisely because it gets under the skin of folks like that. And so this is pedagogical, right? It doesn't have anything to do with penalties or policies, or it has to do with universities ought to be places where we model civil discourse for everybody, right? And modeling is something that's extremely different from punishing.
I'll keep it quick. I agree with 100% of what Professor McConnell just said, and any of us who play a role in advising student organizations on campus, setting aside the First Amendment, I think we have a duty to tell them what's a good idea and what's not a good idea. I mean, you can invite Richard Spencer, but maybe it's not a good idea. So that needs to be said to these young people sometime. They appreciate the guidance when you say it to them clearly, as I frequently do to a lot of these students. What the universities, I believe in rules as a lawyer who has to advise my clients, and what shocks me in some of these situations is that, Berkeley, for example, has one of the top law schools in the United States, certainly in California. And in the middle of this lawsuit, the chancellor admitted to the LA Times, she said, for years, the LA Times asked her, what do you do when a really obnoxious speaker comes to campus? She said, well, for years, what we used to do is, there was a guy in the 90s who was a Holocaust denier. He was making the rounds on campus. So what we did was we had him speak in the middle of the day, like a mile away from campus, with a curfew, and nobody heard him, and that was our way of protecting the campus. And recently, our lawyers have told us we can't do that anymore because it's unconstitutional. So, that's an admission being made by the university where they have a law school. Could it be so hard to pick up the phone and call, the dean of the law school, or frankly any student who's taking con law, and say, is it okay for me to have viewpoint discrimination against speakers and put them away to protect the campus? It's not that hard. They should talk to each other. Why are conservative students bringing speakers onto the campus? It's because there aren't any conservative professors. If there were conservative professors on the campus, I don't think you'd hear this hunger from these students to bring these speakers off the campus. And the liberal students don't have that problem. They have their viewpoint from the front of the classroom, from the podium every single day in every single one of their classes. So some balance needs to be struck, and frankly, these are taxpayer dollars in many cases here in California, so taxpayers should demand that there be some more parity and equity on the campuses.
Elizabeth, we'll give you the last word.
Oh, wow, thank you. I think, I'm really glad we had this conversation, and I think that, it isn't an easy issue. Professor McConnell is right on that score, but I think we can do our best to not make it harder than it needs to be. And I think the modeling is incredibly important. I also think getting exposure to other people's ideas, which is kind of one of the points that conservatives make when they advocate for having their speakers come. But even though college campuses can often seem like they're an overly liberal place, and I should say that I was an undergrad in a very conservative government department at Claremont McKenna, and then went to law school at the much more liberal Yale Law School. I can speak from a perspective on both, but I think that having Professor McConnell speak to not just his conservative groups, but speaking to the liberal groups is important. That's why I value coming to speak with students. Well, I know this is the lawyer chapter out here, but I value going to the Federalist Society student conventions just as much as I do going to the ACS conventions. And I think that being able to look with each other with respect, and frankly, in that modeling, not use words like hysteria, tantrums, mind control, thought crimes. I think that that's important, because then we focus on the issues and the values and the people who are involved. And on that note, I should say that I might have to leave early because I'm doing a Fox interview right now on immigration momentarily, just, I guess, further proving my point.
I think we have time for one question from the audience, if there are any.
Say a conservative speaker come and talk. About 1,000 years ago, when I was in college, there were speakers that came, and I would say, oh, I want to hear him, or I don't want to hear her, and they don't have to go. So you sound like people are forced to go and hear some speaker of a different political venue. And all I'm asking and suggesting, and I haven't heard anybody talk about this, if they don't like the speaker, they don't have to go. But what right do they have to break up the campus and commit crimes?
Yeah, absolutely. And I apologize if I gave that impression. I actually, I think that it's important to have a diversity of speakers. I think the sensitivity that I was speaking to was more about when you have speakers who come to campus like Richard Spencer, who are blatantly white supremacist and challenge the very humanity of a lot of students who are part of that campus community, or Ann Coulter, who wants to say that certain human beings are illegal because they are here without documents. I think having conservative speakers come, no human being is illegal. They are a person. They are here without documents and unauthorized. Bank robbers also are not illegal human beings. They've committed a crime. So anyway, back to the point. Having a conservative speaker express these views is incredibly important. But instead of having Ann Coulter come and talk about conservatives not on campus, why not have Nick Rosencrantz, who is a very well-known, very well-respected scholar who is conservative and will talk about this, but not in a way that is meant only to inflame or provoke. I think having conservative speakers and having liberal students come to them or not as they choose. Conservative students don't have to go to liberal speakers. I think that's part of college. But I think the difference is when there's someone who and is there to provoke, to make these statements that could affect students who feel that their very humanity is being questioned. But again, that's not a reason necessarily to not have the speaker. I just think the university has to think carefully about the context in which that view is expressed. So if we're talking about the marketplace of ideas, how are you fostering that marketplace?
Can I just say I really agree with that, and I think the conservative movement needs to police itself, just as I wish that the liberal movement would police itself.
Can I, on that about provocateurs in particular, agreed with everything that was just said. And I honestly, I think that it's a failure of tactics on both the left and the right as far as student groups. As Professor McConnell said earlier, the student groups who are, and as you said a moment ago, student groups who are inviting provocateurs to suggest that they're inviting provocateurs in order to start a conversation on campus with the left is just, I'm sorry, that's BS. But but on the other hand, the idea that it's effective in quelling that person, in quelling or somehow canceling out that person's message to shout them down is also BS. So my boss, our vice president of legal and public advocacy at FIRE, wrote a fantastic op-ed in the New York Times before Spencer spoke at University of Florida, which I'd encourage people to go read. But the topic was how to deal with the fact that Richard Spencer is coming to your campus and coming up with and offering suggestions as to how students might react in a kind of First Amendment positive, more speech way. But honestly, the kind of no platforming, shouting down idea just sells Milo's book. Nobody knew who Milo Yiannopoulos was before before his message started becoming about his own right to speak on campus. If his book still does well, he's self-publishing it now after the whole Simon & Schuster debacle with them dropping him for publishing it, which we will not get into. But if he still sells books, it's because of a failure of tactics of both the left and the right.
Well, we are actually completely out of time, and I'm told that I'm to announce that lunch service will begin, so you are required to remain seated. But will you please join me in thanking our excellent panelists for their discussion?